Hello, everyone. Welcome to Kevin's Corner. I'm your host, Kevin Horner of Galligan and Manning. Thank you for joining us. I thought what I would talk about today is something that I did a blog on yesterday, which is the Secure Act. This is something you may have seen in the news, or you can certainly Google it, or better yet, look at our website and you can see the overview of it. But it is a proposed change to retirement rules that are focused on trying to get more value to the retiree. And it's not actual law yet, which is why it's still proposed. It's been passed by the House of Representatives overwhelmingly, and will go on hopefully to the Senate, and then eventually will become law in some form. And I wanted to talk about it now because some of the changes will be pretty broad, especially where we're focused on the estate planning. So I want to give a little bit of background on what it is, and so we can talk about what it means for you and what you need to do differently in the future based upon these rules, assuming they're passed as they are. So, okay. There's a lot of good things about the Secure Act. First, no particular order, I suppose, it takes the mandatory retirement age, the mandatory RMD age, where you have to start drawing from your IRAs, your 401ks, takes it from 70.5 to 72. It's designed to recognize that people are going to work longer, not have the same retirements that they did in the past. So that's good. It means you can take it later. You have bigger and better options in terms of how you can invest the money, how you can add money to the IRAs or the 401ks, the length of time of which you can keep contributing to it. And it also has some new and probably better rules for excuses to take money out without a penalty if you have to take it early. It's designed to make the retirement better, but also probably used up more during lifetime, which is perfectly fine. The bad side of it, which is where it impacts our area in estate planning more often than not, is it's probably going to take away the ability to stretch out money to your beneficiaries. Now, what does that mean? Under the current rules, if you leave money in an IRA, 401k to a beneficiary, let's say it's a child, you have the ability, if they're readily identifiable, to be able to stretch it over their lifetimes. Meaning if your RMDs are based upon your life expectancy and they're your kids, so they're younger, instead of taking out your expectation of life, they're going to take it out on their own, which means they draw the money out slower, unless they want to take it faster, draw it out slower and slower and slower, and then that growth in the IRA, let's say, that tax-deferred growth goes longer and longer and longer, and because they're not taking taxes out as you go, you're getting a great investment return on everything that grows in that IRA, because the money can sit there tax-deferred longer and longer and longer. It was a great thing for a beneficiary because if they didn't really need much of the money, they could drag out how long they needed to take it and just get a lot more money that way. One of the things that will probably change with the new Secure Act is instead of having it on the life expectancy of the beneficiary, it's going to be a mandatory 10-year payout. I mean, you can't take it any less than 10 years. And, excuse me, there are some exceptions to that, but the exceptions that are generally being discussed right now are surviving spouse, which makes sense, minor children, mostly because if you took it out on their life expectancy, that doesn't make any sense. Or I should say, if you took it out in 10 years, it doesn't make any sense. And then also potentially disabled beneficiaries. Also sounds good. However, the current rules are going to make some problems as well. If you just want to leave, your IRA to your 50-year-old son, they're not going to get the same advantages. They're going to have to use it up in their lifetimes. You may notice that this accelerates all the ability for the money to come out and then actually have taxes paid on it, which is basically why we're doing this, right? We're taking tax money out quicker upon the death beneficiary, but giving enhanced improvements to the retirement use for the actual lifetime of the retiree. That's the give and take here. But what it means is if you want to leave more value in your retirement to your beneficiaries, you may not be able to stretch it out as long. And that's especially true if you have a disabled beneficiary, because if you do have a disabled beneficiary, yes, they can stretch it out over their lifetime, but a disabled beneficiary is probably using government benefits, is probably on Medicaid or some similar program where they're only eligible based upon the income and assets they have. Their resources are looked at. So leaving them an IRA that stretches out over their lifetime is probably not a good idea in the first place, because you're leaving it to them in a supplemental needs trust. And basically the two are not going to work together, which means you're going to pay out over 10 years directly to a supplemental needs trust and avoid and lose the benefit of stretching out the money. Okay, so what this really means is this. If you have an estate where you have a lot of value in your retirement, which many people do now, They use the money they have during lifetime for their own care. They have value in their real estate in their house. They have value that they've deferred into 401ks and IRAs, et cetera. And then everything in between is what they've been using. If you have a lot of money there, it means ultimately you're going to pass less value to your beneficiaries. So it's first and foremost, we're taking a look at your estate plan and your finances again to see do you want to do this differently? Do you want to reinvest some of that money? Do you want to take it early? And you can fill in the blank based upon your situation, but do you want to do something differently with it? Number two, if you have a disabled beneficiary and you can't get the same value out of your retirement for them, do you want to instead maybe leave them in the supplemental needs trust life insurance, something that will give them a huge influx of cash if they need it, not be dependent upon the growth over a long period of time, and basically be able to fund it in that way? And it's the kind of thing that you'll have to look at in great detail to figure out exactly how it impacts you, but it's sort of the negative side of what is undoubtedly going to be passed in some form in law. In the House, it passed 417 to 3. So at some point, the Secure Act in some form is going to be passed, and this will be probably the negative of it is you won't be able to leave as much value to your estate plan. So that's really the key to this, is recognize you won't be able to pass the same amount of value to your beneficiaries. So you want to look at your estate plan and your finances. And then two, especially if you need a lot of that value going to someone like, I believe, a surviving spouse or disabled beneficiary, look for another way of funding it other than just the retirement so you can maximize the benefits of those individuals. So those are the two parting thoughts on that. A lot of this, it's still proposed law. It'll be coming out in the next year or two, but it's worth thinking about now. If you want, you can all means contact us. You can call us at 713-522-9220. Or you can go to our website, GallagherManning.com, and get a free consultation so we can review your estate plan and figure out how this is going to impact you to make sure you can still pass your legacy to your beneficiaries like you want. So with that, I'll say thank you to all of you. If you have any questions, feel free to send them in. I'm happy to address them. And I look forward to all seeing you again next Thursday for Kevin's Corner.